what will happen if the one we depend on pass away due to accidents? Okay, the question, the topic today is very much related to this. Okay, accident could be together with the commercial vehicle, or could be a working place, could be any reason. But if let's say this accident happened to our loved one and we are the one that depend on him, what can we do? In many situations, we end up in a very clueless situation, sad and clueless situation where we don't know what to do. That is why today, okay, we have invited Mr. Sashpal here, okay, to come and share with us. Okay, just let me briefly tell who is Mr. Sashpal. Sashpal is basically is a partner of Razi Sheikh Ahmad and Sashpal. Okay, Mr. Sashpal has practiced as a litigation and a corporate lawyer, and has handled various high-profile and complex litigation involving injunction and dispute, not only in Malaysia, it's internationally. All right. So without further ado, I wanted to check if Mr. Sashpal is already with us.
Okay. Good evening, everybody. To those who were with us last month, I believe, welcome back. The previous talk that I had was with regards accident claims, specifically for personal injury claims. But today, however, what I'll be focusing on is fatal claims. I'm from RSAS. I've worked known Max and the guys at MCM for a very long time. So I will begin by saying that, malang tidak berbau. Accidents happen anytime to anybody. So education is sort of an insurance policy for you. When it comes to fatal claims, more of a life insurance policy. So it's not just for you, but your loved ones as well. It will be good to know, basically, if something happens, if you were to die in an accident, what can your family do? Most of the time, this is the time when the family is left without a support. They are clueless as to what to do. And many instances I have actually encountered where the family are not even aware that they can file claims specifically for loss of support. I will come dwell further into it. What is loss of support? Before that, it's derived from the law of negligence, law of tort, right? Where there's a duty of care owed towards your neighbor. In this case, when you are driving a motor vehicle, you owe a duty of care towards all other road users. I'm sure almost all of you would be aware of the accidents involving cyclists that has been on the upward trend. It has always been there, but recently it has caught the spotlight. There were these young kids who were involved in a fatal accident in Johor Bahru. Recently, the driver was said to be was not at fault when she was charged in court. All right, and there was also another incident recently where a cyclist died. I believe he worked at Astro, and he was riding his bicycle somewhere in Putrajaya or Cyberjaya. So in those kind of instances, what can the family actually do? Are they able to claim any kind of compensation from the drivers of those vehicles that collided with the deceased? That is what we are here to explore today. But before that, I'd like to run through the what we spoke about the last time. All right. For example, here in Singapore, a record 13.6 million was paid out to a cyclist hurt in a road accident in Bukit Batok in Singapore. All right. He was basically a Swiss national. He suffered a traumatic brain injury. He was thrown off his bicycle. He sustained head injuries. He said spent 6 months in hospital, and the person who collided with him pleaded guilty in court, was fined, banned for driving. But you have to take into account that the fact that he was fined or banned from driving is not really, I would say, connected to the claim under negligence, which is a civil claim. In any event. All right. So in this case, his widow actually went on to file a claim, and He suffered extensive injuries. As you can see, there are many heads of injuries that can be claimed. Loss of future income, pre-trial loss of earnings. He even managed to claim, I believe it was for Botox to his lips, but nerve injury to his face, all sorts of claims, which many people are not really aware that you can claim for all this. And his claim came up to 13 million. In this event, he did not die. He survived the accident. So what would happen if he had actually died in that accident? How much would the widow be able to claim? All right. As most of you would be aware, all motor vehicles in Malaysia, it's compulsory to have third-party insurance claims, regardless whether you have a comprehensive cover or not. Third party is compulsory. So basically, when an accident happens, I'm sure pretty much many of you would know or would have known someone who was involved in an accident, considering Malaysia is one of the highest accident rates in the world, one of the highest in the world, I would say, based on statistics. So it does not hurt to be prepared for if something were to happen. All right. And another example is where this cab driver, 73 years old, gets jailed, 8 years driving for fatally crashing into a jaywalking pedestrian. The jaywalker died. All right, the jaywalker died. So the cabbie then was sentenced to a jail sentence and also 8 years of driving ban. But the question which we are going to explore today is what happened to the jaywalker. Yes, jaywalking is particularly in Singapore is an offense. However, the courts have taken many different approaches when it comes to breaking the rules and who is at fault in causing the accident. It does not automatically mean that if the jaywalker is at fault. All right. For example, if the jaywalker is at fault, he's crossing at a place where he's not supposed to cross, and an accident happened, it does not mean that he cannot claim. Okay, like in this case, if the guy was jaywalking and the cab driver was still found guilty, a civil claim is different from this sort of offense under the Road Transport Act. That is something that you have to bear in mind. All right, for like the example I was talking about, the cyclist. The question then comes to mind is, can those young cyclists who died in the road accident in Johor Bahru, or can their families, or can the widow of the cyclist who died, say it was in Putrajaya, I believe Putrajaya, Saibajaya, can his widow and his children file a claim, a dependency claim? That is what a dependency claim essentially means. It's something that is filed in court by your dependents. All right, I'll come shortly to what does a dependent mean. Basically, what the first step that the family takes in such an eventuality is, of course, to lodge a police report, which you would need either way for your death certificate, and to compile whatever medical documents or records that you have. It is tough times, but it will be very helpful if one of the family members goes around and starts compiling the deceased income documents and whatever documents, bills, receipts of funeral expenses that has incurred. It's always good to keep the receipts, because all those expenses can be claimed from the insurance company. And then what usually is done is it's advisable to speak to a lawyer and to hand over all these documents that you have, so the lawyer would be able to advise you whether you have a valid claim or not. All right. Remember, this is something very, very, very important limitation. Okay, it's you have a time limit. The court, basically, the law says that you should not sit on your rights if an accident happens, you have 6 years to claim under personal injury claim, and from the time of accident, and 3 years from the time of death in a dependency claim. And remember, you have to remember this. The limitation time is very, 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 very important. I have done cases before where this also applies for your standard breach of contract as well, 6 years. I've done cases before where the limitation is, it has like literally 2 days to run, and so if it has to be done, it has to be done. You have to file a case in court in the middle of the night. You have to do it, because once that limitation sets in, that's it. That's the end of it. You cannot file a claim. All right. In a nutshell, as what I spoke about the last time, bodily injury, you're basically claiming for your injuries that you suffered, your injuries, your loss of income, where you are actually injured. But in this case, where a loved one, someone that you are depending on, a dependent, you are dependent of someone. For example, a spouse, your child, your parents, so what can you claim when they pass on? You claim for loss of support, which, for example, a son has been contributing, say, 500 ringgit a month to his mother, and then the son dies in an accident. Right? So the mother is saying that, hey, look, now I'm not going to get that 500 ringgit anymore because my son is no longer here. So that is what loss of support means. It's loss of financial support, not any other kind of support, not emotional support. It's loss of financial support, which you have suffered as a result of the death of a loved one. All right. Now, of course, there are other expenses that you can claim. Funeral expenses, bereavement is basically kesedihan, right? That's a fixed amount in law. The amount is fixed at 30,000. Okay, so moving on to the actual claim. There are two parts to your claim. One is liability, second is quantum. That's what we call L and Q, liability and quantum. The first thing that has to be looked at is who is liable for causing the accident? Who is responsible for causing the accident? Our law works on fault based. Are you at fault at causing the accident? Are you both equally at fault? Of course, in this case, the one party has actually died. So it's not so straightforward in seeing who is at fault. For example, just say a lorry collided into a motorcyclist, and there's no CCTV evidence. There's no independent witnesses, someone who actually saw the accident. Then basically what the court will look at is, of course, they will look at the lorry driver's police report, which most likely and almost always one-sided, unless you have a very honest driver there. And so you have the police report, and then the police does the investigation. They interview the witnesses, they take statements, they look at the marks on the road, scratch marks, where was the for example, the serpihan kaca, where did it fall? So all sorts of indications will be looked at to know who is at fault. It's not really a very simple task in this kind of case, because you only have one version. That's the version of the lorry driver. See, because the dead can't speak, but they do speak in many different kinds of ways, which is what the police and, of course, the lawyers try to seek out. Okay. And of course, the police and the courts, when it comes to assessing liability, they go back to the basic road transport rules, the highway code, which I have stated a few here. For example, Rule 42(1)D, menunggang basikal dengan kedua-dua tangan, tidak memegang pemegang. Okay. Membawa penumpang semasa menunggang basikal. You cannot have a penumpang on a bicycle. You are racing, menunggang secara bersaing. Menutup kepala dengan kain. All sorts of things, funny things you will find in the rule. I don't understand what they mean, menutup kepala dengan kain. basically I guess is blindfolded, menunggang bicycle tanpa brake yang baik and all that. And this is just for bicycles. This example is just for bicycles. So if you want the complete rules, I have a set of it. I can share it later with MCM, and which we also have the ebook which we are producing together with MCM, where we will summarize all the rules for anybody who requires it. All right. So number one, what you look at is liability, who's at fault. Number two, how much can you claim? So when you know who is at fault, then you need to know how much can you claim or who can claim. All right. So in a fatal accident claims, there are two headings. One is a dependency claim, what we are talking about today. Who is a dependent? Your spouse, parent, child, or disabled person under your care are your dependents. Are grandparents dependents? Yes, they are too. All right. So under dependency claim, you claim for funeral costs, expenses. Bereavement is a fixed amount fixed by law at 30,000, and then you have loss of support. All right. So these are the three headings that you can claim, which will be good for you to remember. When it comes to estate claim, what estate claim means is that, see, dependency claim is claimed by someone who was dependent on you. An estate claim is filed by your own estate. You know, when you extract your LA, letters of administration, and then your own estate can actually file a claim. Okay, where is this relevant? I give you one example. Say Mr. X, all right, he met with an accident and then he died 10 days later. He did not die immediately. So what happens for that 10 days? What happens for that 10 days is that he was in pain. He was suffering for that 10 days. So his estate then comes and claims for his pain and suffering for that 10 days before he died. From the time of the accident till the time of his death, his estate comes in and files a claim for his pain and suffering, all right? And any other costs incurred, which I've listed down there. So after he dies, then what is valid is the what comes in is the dependency claim, all right? Moving on. I will focus today on dependency claim. Okay, so what we have here is your dependency claim, as what I explained. You have three headings: funeral costs. Someone has died. There's a Chinese funeral, of course, costs a lot more, especially if he is buried in somewhere like in Nirvana. Indian Malay funeral cost usually is lower. All right, so it'd be good to have whatever receipts, and you can even claim for like the hearse charges, to transport the deceased to the burial site, and all sorts of related expenses which you can claim. Bereavement is automatic, all right, for the dependents. And loss of support, remember this is very important, is only claimable if the deceased was aged below 60 and he was earning. So if someone who died, say Ali's father died, all right, and his father was not working. He was just sitting at home, all right. So he was obviously not contributing anything financially to Ali, right? So there's no loss of support. So the right word to use would be loss of financial support. So if you have been receiving financial support from that particular person, then you can claim. So say for example, an infant dies. The infant was not contributing financially towards you, the parents. So there's logically no way you can claim for loss of support, because your infant was not paying you a salary, right? I mean, he was not earning a salary. Unless, of course, he was. Strange things happen. Some kids, perhaps they start working at the age of 9. They go into the showbiz industry and they're earning a lot and they're actually contributing to their parents. So, yeah, that can happen. But I've never personally encountered it. Yeah, but it's possible. It's possible as long as you were below 60 and earning. All right. Why 60? because our retirement age has been fixed at 60 in Malaysia. Okay, that's why 60. If you are okay, the formula is this. All right. I'll run through the formula after this. Let me explain who are dependents. Dependents are your spouse, parent, children, and disabled person under your care. Your child includes son, daughter, grandson, granddaughter, stepson, stepdaughter, legally adopted. Right? Not just a namesake, has to be legally adopted. Parent includes father, mother, grandfather, grandmother. So are siblings your dependents? No, even though they are depending on you all, but they are not your dependents. They don't fall under the category of dependents. What about adopted child? Yes, if the adoption was legally registered. What about dependency of a child upon remarriage of parents? Yes, of course, you can. Remarriage of the parents does not affect the dependency of a child. Okay. What about a divorced wife? So this is a bit of a tricky question. You won't really encounter, I don't really encounter these sort of scenarios, but it's possible. It's possible, generally no. But I have found a scenario where the wife actually deserts her husband prior to his death. So they were not technically divorced. Then possibly yes. So it can, there are ways around to look for loopholes if someone was looking for it. Okay, and a legally separated wife, no. Unmarried woman with children, no. They are not dependents, right? Okay, moving on. Loss of support, which I was speaking about just now. Only claimable if the deceased, only claimable by the dependents if the deceased was below age 60 and earning. All right. So the formula is this. This is the formula. Wait, hold on. Okay. Loss of support equals, this is a bit of mathematics, all right? It took me many years to study, but I'm trying to summarize as easy as I can. Loss of support equals to multiplier times multiplicand. It's a formula, all right? The number of years which your deceased, right? For example, Ali died, all right? Ali's son now has lost the years of support which the father would have given him. Say the father was 15 years. So say the father was 50 years old, right? So the Ali has basically lost that 50 to 60-year-old, lost the years, right? Years of support which the father would have given him if the father would not have died. Okay, so it's years of support times the amount. Okay, for example, if the deceased was below 30 years old, say Ali was 29 years old. If Ali was 29 years old, Ali's mother can claim 16 years loss of support. 16 years loss of support. So the multiplier will be 16. If Ali is below 30, it's automatic 16. All right, just remember that if the person who died was 30 years and below 30 years old, the loss of support, the loss of years is automatically 16. Your multiplier is automatically 16. If the deceased was say 55 years old, so you take 60 minus 55 divided by 2. That's how you get between the age of 31 to 60. If he was above 60, 0. There's no loss of support. I hope that is clear enough. I have an example as well. Okay, the multiplier, loss of years of financial support that the deceased would have given his dependents. The deceased would have given his dependents. See, if he did not die, how much support would he have given to his dependents, his spouse, his children? This is what we are claiming for. This is what you're claiming for. If a lot of logic applies here, and of course the formula as well. If it's above 60, the law assumes that you're not earning, because that's the retirement age. So if you're not earning, there's nothing you could have given to your family, right? If you die. So, and if you are below 30, all right, if you are below 30, why we take 16? 16 is the maximum amount that maximum amount of years that you could have contributed to your dependents. It's just a formula which the courts came up with long time ago, all right? Okay. Multiplicand. Multiplicand, what does multiplicand mean? All right. Remember, loss of support is multiplier years times multiplicand amount. So we already know the years. Now we need to know the amount. Okay. Say the deceased had a net income of 2,000 ringgit. Okay. Minus what he would have spent on himself. His rokok money, duit beli rokok. His money on petrol. His money on his own entertainment, because even if he was alive, he would have spent the money on himself, right? He did not give the money to his wife, right? This money that he would have spent on himself, all right? Minus, for example, he has been donating to an orphanage, so either way, he has been donating to the orphanage. He's not giving the wife. So the way to look at it is how much money in hand did the wife actually get from the husband on a monthly basis. That is a simple way of looking at multiplicand. Or the simpler way, what the courts do, the tip here is you take the guy's earnings, you minus 1/3, you get the multiplicand. He was earning 3,000, minus 1/3, you get 2,000. So that means assumption is he gives 2,000 to his dependents. That's a simple, easy formula to remember. Okay, one example. Ali was riding a motorcycle. Okay, as he reached the traffic lights, he noticed it was green. Okay, so he proceeded straight, but then he suddenly collided with a car. The car driver alleges that the traffic lights were green on his right of way, but Ali then alleges that the lights were green on his right of way. In this case, if Ali actually died, so he can't really make any allegations. So there's only one version, right, which the car driver is saying that his right of way was green. But the usual circumstances, what the court would actually usually take is if an accident happens on the traffic lights, unless there's evidence to the contrary, most of the time is assumed that both are at fault. Okay, so in this case, Ali died as a result of an accident. His dependents can file a claim, a dependency claim, assuming Ali was 28 years old. If he was 28 years old, earning 3,000 a month. Okay, so what is the formula? I hope you all remember. 28 years old, your multiplier would be 16. All right, earning 3,000 a month, minus 1/3, you get 2,000 a month. Liability 50% because accident at the traffic lights. So your damages will be funeral costs at 3,000, bereavement 30,000, loss of support 16 years. Okay, so it's 2,000 times 12 months times 16 years, that's 384,000, becomes 208,500 ringgit. Okay, that is the simplest way that I can explain how do you derive that a figure for the dependency claim. It's a simple formula to remember. Of course, you won't remember it the first time around, but if anybody needs any further assistance, please don't hesitate to approach MCM for the ebook that will pass on to them later on, right? See, there were amendments to the law. Previously, it was the years of the retirement age was set at 55. Of course, the law has to keep up, so it has been increased to 60, and the bereavement amount was 10,000. It has increased to 30,000. So it is good because 10,000 is a bit too low. It was based on a very, very long time ago, from 1984, which thankfully has been amended to 30,000. It is a lot more useful. So now, a question which I'm sure many of you are asking, those in your mind, where I started off, those cyclists who are riding the bicycle. Okay, those cyclists who are riding a bicycle, for example, in Johor Bahru, how much can they claim? What would the loss of support be? Would there be any loss of support? Okay, they were definitely below age of 16. Okay, and they were 16 years would therefore apply. But are they earning? If there was evidence of any earning, then it's possible. Most likely there wouldn't be, but I wouldn't know. That would depend on the evidence which the dependents can actually adduce that they were actually earning at that point in time. So if they were earning at that point in time, then you look at the loss of support, all right, the years times 12 times 16, the amount which they were contributing to the family times 12 times 16. Funeral costs and bereavement is as of right. So minimum they would have 30,000+ ringgit claim. But again, it goes back to liability. Who's at fault in causing the accident? As what I explained earlier, L and Q, liability and quantum. You cannot just look at quantum. If you are 100% at fault, you are 100% liable, you still can claim. So remember that, L and Q, liability and quantum. All right. What will not be taken into account, okay, in your loss of support? For example, any sum payable under EPF, any pension gratuity, any sum, no damages to be awarded to a parent on the ground of being deprived of the services of a child, or services of society of his wife. It has to be monetary contribution. It cannot just be love and care and tender care and the fact that you have lost your wife. Yes, it is sad that you have lost your wife or a child, but unfortunately the law will not allow you to claim for loss of support unless there's an actual loss of support. But you can of course claim for funeral expenses and bereavement. Okay. The loss must be due to family relationship, not any contractual relationship. You cannot claim for loss of service or attention of a wife or a mother. All this cannot be taken into account. Okay, what can be taken into account is the court shall not take into account any prospect in earnings. All right, any prospect in earnings or any, for example, you come to court and say that there was a prospect of an increment, there was a prospect of him getting a job, but if there's no actual contribution, okay, it has to be an actual contribution. Put it as simple as that. Something which you are actually receiving. Okay, an actual contribution, then you can claim loss of support. Not something which you might have received if he had lived on, because the court doesn't speculate. The court doesn't speculate. It goes based on evidence that it has before the court. Okay, so documentary evidence, witnesses are all very important. You need to summon the deceased employer to court. You need to prove his earnings. You need to prove how much he was earning every month. And of course, you won't have in writing how much your husband was giving you prior to his death, unless some people actually put it down in writing, which I'm pretty sure most don't. Then we will fall back to the 1/3 rule. Or if some try to push for a higher amount, then it will depend on your evidence that you can produce in court. Okay, which will be challenged, of course, by the lawyers representing the insurance company. Okay. Living expenses. As what I explained just now, living expenses. Your husband, say the dead husband was earning 3,000 a month. So what were his living expenses? Expenses which he spent on himself. Okay. The court has gone on to say in the past, it is only logical that some part of the plaintiff's earnings, some part of it must have been devoted to his own maintenance. Nobody takes his entire salary of 3,000 and gives it to his wife. Maybe they are, but I don't know. But the court assumes that there's nobody. Okay, unless you can actually prove it, that the entire 3,000 was given to you. Of course, if there is proof, the court will consider that. But what the court has generally said that it's only logical that some part of plaintiff's earnings must have been devoted, or deceased earning in this case, to his own maintenance. But no matter how logical it may appear to be, it can only be deducted if the amount is either admitted or proved. Usual practice is to deduct 1/3 of his earnings. Okay, say for example, you appear in court and the lawyers for the insurance company do not challenge that the living expenses part, so, and it's silent about it. Then the court is going to assume that there's no deduction to be made, so you will get the full amount. But that's very rarely the case. Any lawyer worth their salt would actually challenge it. So then you would fall back to the 1/3 rule. Okay. This usually assumption is food, that money that you spend on yourself, like for food, cigarettes, entertainment, all sorts of those kind of expenses, not including shared expenses, for example, car installments, rent for the house and all that. That's not deductible, right? Okay, moving on. Okay, this is one example. Okay, say a wife took over the Felda estate of a deceased husband and obtained a net income of 425 ringgit from it. Should that sum be deducted from the dependency claim? Okay, so they had a Felda estate. She took over the husband's estate, or in another case, you had a business. The wife took over the business and actually earned 525 ringgit from it. Okay. In this case, what did the court go on to say? He says that it's a generally acceptable principle that benefits accruing to the dependents by reason of the deceased death should be taken into account to reduce, the dependency claim. Generally, you should reduce the dependency claim, okay, because that was not the actual amount which the deceased was giving you, okay, benefits accruing. However, these benefits should not be derived at the expense and effort of the dependent. In this case, she actually toiled the land herself upon the death of her husband. Okay, so you cannot say that she's earning 425 ringgit from her own effort. So now the dependency claim of 500, you minus 425. So the husband technically is only giving her 75 ringgit. That's not the case. Okay, because this is on her by her own effort. Even though it's the same land, the same Felda land or the same business, but if it's by your own effort, it's separate altogether. All right. You are still entitled to a full dependency loss per month. Okay, this is what the court. This is an actual case which happened in court, where she actually virtually toiled the land with her own hands. The money she earned should not be deducted from the dependency loss. Okay, another example. What if the wife remarried? This is also an interesting situation. Very rarely you come across this kind of situation. If the wife had remarried, can she then come and claim for dependency loss? Okay, technically yes. Okay, technically yes. This case had actually elaborated on that principle. There were instances, a previous case which where the court minus 20% to the widow who remarried. They only gave her 20% and the rest to the children. So as you can see, right, it's not really a very straightforward fixed kind of situation. Where the situation varies, then the court might have to look at the circumstances. Okay, they might have to look at the circumstances. What happened in this case, this Chai's case, where the widow remarried, the Court of Appeal actually reversed the 16 years of years of purchase. The 16 years loss of support, they reduced to 8 years. The court said no, she's entitled to a full 16 years. Okay, full 16 years. You should not reduce the number of years just because she had remarried. Okay. There are many other examples that I can actually provide. But for example, okay, in a situation where, okay, this is a very unique situation which very rarely you would encounter. Say someone who met an accident. Okay, Mr. X met with an accident, and say 1 week later, was a very horrible accident. 1 week later, he committed suicide. Can his widow then claim for dependency claim? Okay, can he claim? It has to go back to what was the cause of the suicide. So I wouldn't say no. I wouldn't say yes to. it would go back to the question of what actually caused the suicide. Is he naturally prone to suicidal tendency, and because of the accident it was aggravated and he actually committed suicide? So then the wife can actually come and claim for that 10 days where he was alive, the estate claim, and of course the dependency claim where he had actually died. Yes, it's possible. I wouldn't discount that. I can't remember offhand if it has actually happened before, but it can be done. All right. So there are many different variations to dependency claim that one might encounter. Okay, but
Mr. Sashpal, need to wrap up already, huh?
Yes, I am done. Actually, almost done. Okay, these are the usual checklists of documents that we require: the police documents, independent witnesses, police results, investigation results, sketch plans. These are all provided for by the police. Medical documents, post-mortem reports are very important, and of course we need to know if that car that collided into them has motor vehicle insurance. Not all cars have insurance, all right? So remember the checklist, police documents, medical reports. These are very important. Okay, all these documents should be given to your lawyer. How do lawyers assist? In many ways, like what I elaborated just now. There is no hard and fast rule. Even the law itself has bent and twisted many times, and different courts have come up with different outcomes. But most of the time, it's pretty straightforward if the circumstances are straightforward. All right. So I hope that the talk today was of use to our listeners. And I will end with this. Okay, the court has actually decided in 2020 that a customary marriage means before 1984, where the marriage was not registered. In this case, the widow was able to claim for SOCSO. Okay, but in our Civil Law Act, she wouldn't fall under dependent, would she? Because to be a dependent, you have to be a legally married wife. So the question now arises is, will the law related to dependency claim also cover customary marriages? Which I'm unable to answer, but I hope that the answer would come up soon, and some matter will be brought up to court, and this question would be answered. All right, so that's all for today. Thank you very much, and I hope to see you all soon again. And I move on to passing on to Suren.
Anyway, thank you so much for your time.
You're welcome. Thanks.
I hope to see you again for different topics, and we are so excited to learn more from you. Okay.
Thank you.